Our job here is to review the judicial branch in as much detail as possible so that you might get a better test score on the end of your baseline. Let's start off again talking about checks and balances. Remember, our Constitutional Convention in 1776 in Philadelphia had the task of creating the best system of government, not a monarchy, but also not a state of nature. So they came up with the idea of creating three branches. We've got the legislative, the executive, and now the judicial branch. They each can check each other's powers. In the judicial branch, the job is to define or interpret the law. What does the law say? What does it do? And when they check the president's laws, they declare laws constitutional or unconstitutional. They do the same thing with the House and the Senate or Congress or the L branch. They declare laws constitutional or unconstitutional. That is step one. We also talked about throughout the year the criminal court process, and there are 13 steps to a criminal case. We taught you the phrase, Aunt Betty picked grapes in Allegheny, Pennsylvania. She offered warm cans very sweet. And a helpful thing to do is to remember our mock trial formation. And we first had an arrest of the defendant. Okay, they were booked or fingerprinted. There was a preliminary hearing, which is picked. That's where all the evidence is gathered by the DA or the prosecuting attorney. The district attorney is the DA or the prosecuting attorney. And then all that evidence is sent to a grand jury, a jury of about 12 to 24 people that see if there's enough evidence for a court case. If there is, formal charges are brought up in an indictment. That's what those are, formal charges. And then the defendant shows up to court, which is an arraignment, and enters a plea. In our mock trial case, they entered a plea of not guilty. Then Pennsylvania stands for pretrial motions. Do we need to throw out evidence or move the location of the trial to ensure fairness and equality in a trial? She stands for selection of petit jury. This is where a jury of your peers is selected. It's about 12 people. And then in our mock trial, we started off with opening statements where the prosecution goes first and the defense second. That was followed up by witness testimonies. The word WARM stands for witness testimonies. And then CAN stands for closing statement, where prosecution summed up their remarks followed by the defense. The jury then went to deliberate. They came up with a verdict of guilty or not guilty. And if they were found guilty by their jury of their peers, the judge gave them a sentence or some kind of consequence. There were several major Supreme Court cases you needed to know. I'm going to cover the 11 we covered in class, and then one final thing. So let's start with the first one. In 1803, Marbury versus Madison case hit the Supreme Court. This case was important because William Marbury here was not given his letter of appointment as an official judge by the U.S. president, by William Madison here. So he sued William Madison, and he lost because the power of judicial review was created. And in that case, it was decided that judicial review would be the law of the land, the Constitution would be the law of the land, and that we can't go against the Constitution. So that is why that case, Marbury versus Madison, is important. In 1896, the case Plessy versus Ferguson took place in Louisiana, and in that case, it was decided by the Supreme Court that separate but equal facilities was allowable or legal. That was overturned in 1954 in Brown versus Board of Education in Kansas, where Linda Brown had to go to an all-black school, even though she lived closer to the better white school. And in that case, it was decided that segregation is unconstitutional. In case number 4, Korematsu versus the United States, this man was forced to go to a relocation center for Japanese Americans because of the attack on Pearl Harbor. The Supreme Court ruled that it was 100% allowable by the U.S. government to relocate him in fear of the Japanese future attacks. In number 5, New Jersey versus TLO. This was in the 1980s. A girl was caught smoking in the bathroom, and her principal searched her belongings and found weed, pot, marijuana, whatever you want to call it, a list of buyers and money. And the student lost the case. The court said that if there is reasonable belief, we can search your belongings. And that does not go against the Constitution. In case number 6, this is Miranda versus Arizona. It was deemed by the court that you have the right to remain silent and you have the right to an attorney, even if you can't afford one. In case number 7, Gideon versus Wainwright, this man was wrongfully accused and sentenced to prison. He fought for his own rights, and he won a retrial because he could actually not afford a lawyer. And under the 6th Amendment, you're allowed to have one. So you are allowed free counsel even if you cannot afford one. In case number 8, Roe versus Wade, 1973, it was the abortion case. Abortions were ruled allowable by the federal government and protected for the first 3 months. States could decide the next 3 months, from 3 to 6 months, and from 6 to 9, they were not allowable. This was recently thrown out in 2022 or 2023, and it is no longer the case anymore. States have the right to decide in abortions allowable or not. Last row, number 9, is Tinker versus Des Moines. Mary Beth Tinker, I should say, and Chris Eckhart wore black armbands in protest of the Vietnam War at school peacefully. They were suspended. They took the case to court, and they learned that their freedom of speech does not end at the schoolyard gate. They should not have been suspended, and that was a free speech right to wear these bands on their arm peacefully. In case number 10, Mapp versus Ohio, Doralee Mapp was given a false search warrant or a fake search warrant. Police broke in looking for a fugitive, didn't find one, but they found obscene materials. And because they found that evidence illegally, she won her case and they had to throw it out. So you have the right to be protected against unreasonable search and seizures. And the police took her items illegally, and she ended up winning her case. In number 11, Texas versus Johnson, it was actually deemed allowable free speech, symbolic free speech specifically, to be able to burn the United States flag without breaking the law. That is a summary of your major Supreme Court cases. Finally, you might be asked about the severity of murders. All right, there's 3 types. The most important and the highest level, I would say, I shouldn't say most important, but the highest level is first-degree murder. This means you plan it ahead of time, you go to the place, and you murder the person intentionally. The key there is that it is pre-planned, okay? Pre-planned. Second-degree murder is not much different. The only difference is it's unplanned, but you still intended to kill the person. When you got there, you got mad at him, for example, and you killed him. That is second-degree murder, but it wasn't planned ahead of time. Manslaughter is just known as the unlawful killing of a person without intent. It is like driving a car, you're texting, whatever, and you cross the center line, and you kill somebody because you run into them. That would be manslaughter. Boys and girls, that wraps up our Judicial Branch review. Hopefully it was helpful. Hope you get a better grade. Good luck.